Thank you for watching the Huntsville Area Association of Realtors on-demand training tutorial named Understanding Alabama's HB 230. Today we are going to be talking about the new legislation that's gone into effect, signed by Governor Kay Ivey. And let's get right into this with an update of when these practice changes will go into effect. And as you can see on screen here, Act 2025-59, also known as HB 230, will take effect April 18th of 2025. So, some significant challenges have impacted Alabama licensees and realtors and their business practices. From these developments, including lawsuits, a Department of Justice investigation, and a National Association of Realtors NAR settlement approved by a federal court in 2024, introduced rules that conflicted with existing Alabama law. These developments created confusion and challenges for both real estate professionals and consumers. The 2024 NAR settlement introduced a rule requiring written agreements with prospective buyers before showing properties. This raised concerns among licensees, consumers, consumer advocates, and the United States Department of Justice, who argue it limits consumers' choice and raises antitrust issues. Alabama and its real estate licensees were not a party to the lawsuit, yet the settlement provisions affected real estate transactions statewide. HB 230, and also known as Alabama Act 2025-59, AAR, the Alabama Association of Realtors, pursued solutions during the 2025 regular legislative session to resolve these challenges and ensure clarity and consistency. Alabama Act 2025-59 was signed into law by Governor Kay Ivey after passing both chambers of the Alabama legislature. This new law, again, will take effect on April 18th, 2025. So, just for clarification, HB 230 is the original bill as it was introduced and debated in the Alabama legislature. Once it passed both chambers and was signed into law, it then became Alabama Act 2025-59. So essentially, they refer to the same legislation, but HB 230 is the bill's designation before becoming law, while Act 2025-59 is its official reference after enactment. You may find when contacting the Alabama Association of Realtors, this is going to be referred to as HB 230, and you may find when you call the Alabama Real Estate Commission, they may reference this act, again, as Act 2025-59. So, what are some of the key provisions to HB 230? Well, the new law is related to three main topics: RECAD, brokerage agreements, and referral agreements. RECAD reaffirms that you must present the RECAD brokerage services disclosure to the consumer before any confidential information is exchanged or any brokerage services, including a property tour, are rendered. Number two, I'm referring to the Agency Disclosure Office Policy. Throughout the course of this training, I'm going to be calling that the ADOP, ADOP. And the ADOP requires that, one, general information about how your brokerage is compensated be added to your Agency Disclosure Office Policy. This is a requirement under Alabama Code 34-27-83. And two, a copy of your ADOP is presented to the consumer along with the RECAD brokerage services disclosure. So it's important to note, while we're talking about HB 230 and RECAD, that RECAD disclosure encompasses two documents: the brokerage services disclosure form and the Agency Disclosure Office Policy, aka ADOP. So here's the RECAD itself. That form is not going to change. It is the same document that the Real Estate Commission has provided and that you will continue to use. RECAD is not currently required, by the way, when working with corporations, nonprofits, professional corporations, professional associations, and a list of other different entities under the Uniform Partnership Act. You can find a full list of those entities at the Alabama Code Section 34-27-82. So this will continue to be the case moving forward. One question we get quite a bit is the RECAD required for buyers attending an open house? And the answer to that is no. Licensees are not required to provide the RECAD brokerage services disclosure form or the agency disclosure office policy, ADOP, to prospective buyers attending an open house. So let's follow that up with another question. Is RECAD required for a listing agent who is showing their listing to a prospective buyer on a private tour, not an open house? And the answer to that is yes. If a prospective buyer is not working with another licensee, the listing agent must provide the prospective buyer with the RECAD brokerage services disclosure form and the ADOP before the tour takes place. Let's talk about the compensation disclosure of HB230, which increases transparency and disclosure by requiring that your ADOP, which includes a general explanation of agent compensation, is included. So many agents are asking, where do I get a copy of the ADOP? Well, you will need to contact your qualifying broker for a copy of that form. If you already have a copy, be sure to verify it's the most updated version, as suggested language from HAAR's legal counsel has been provided and needs to be updated into that ADOP. So for qualifying brokers who may be asking, what do I need to do to my brokerage's agency disclosure office policy to make it compliant with HB 230? There will be some slides coming up in just a few moments that will help navigate those questions, but to be compliant with the Alabama real estate license law as of April 18th, 2025, your agency disclosure office policy will need to include both, one, the brokerage services that your company offers, and two, general information about how your company is compensated. So again, suggested language is coming up here in just a few moments in some slides, and I'll also be providing some references, some resources that you can gather online after this tutorial is completed. So RECAD/ADOP, all right, are the two forms that we're talking about that you must give consumers a copy of your updated agency disclosure office policy along with the RECAD brokerage services disclosure. You should ask the consumer to sign, but they aren't required to do so. So by April 18th, the qualifying broker or the company owner must update their ADOP with general information pertaining to compensation models, but do not require specific rates or amounts to be included. So again, some things to be considered possibly in the ADOP for brokerages could be, one, do you charge a flat rate or maybe a percentage of the sales price, or do you charge an hourly rate? Some other things to consider may be what fees or charges are applied up front, or are they due at closing? Do you have any cancellation fees when working with a buyer? Would you include language that states you might seek compensation from the seller first? Keep an eye out again for those updates here in just a few moments, and consult your legal counsel for that document. So, what is the big shift going on and with the changes from HB 230? Let's just review this one more time. The big shift is simply what forms are now required to be presented and the timing of those forms. The NAR settlement had said that a written buyer agreement was required before touring a home. No longer. State law supersedes NAR policy. So before touring a home, the two RECAD documents are required to be presented: the Real Estate Brokerage Services Disclosure and the ADOP. So the question remains, does the new law mean I can't enter into a brokerage agreement with the buyer before a tour or at some point before I help them submit an offer to purchase? And the answer to that is no. It is still a best practice to enter into a written brokerage agreement with the buyer as early in the home buying process as the buyer is willing to do. If you have a buyer consultation meeting before a property tour and the buyer would like to sign a brokerage agreement, you may legally do so. If during the home search process the buyer would like to sign a brokerage agreement before submitting an offer to purchase, that is also permissible. So let's focus now on the ADOP, the Agency Disclosure Office Policy, and a guide for qualifying brokers. And I want to make absolutely certain for the next few slides and the next few moments in time while in this tutorial that the information provided here and the guides that you'll be seeing in the upcoming slides is for information purposes only, and it is not intended to be legal or business advice. If you need clarification on the language presented here or what you are putting into your agency disclosure office policy, please seek legal counsel so you can have that peace of mind and have approval on that end. I will also be providing information and resources at the end of this tutorial where you can reach out to AAR's legal helpline for additional help. But let's talk about this guide where it says Alabama license law is changing on April 18th, 2025. And to comply with the new requirements, qualifying brokers will need to update their company's agency disclosure office policy and help educate the licensees in their brokerage about the new rules. This guide was created to help qualifying brokers ensure their brokerage is compliant by April 18th. So let's talk about the current ADOP requirements. An Agency Disclosure Office Policy, aka ADOP, is the document that outlines the brokerage's services that your company offers. You may know it by a different name, such as the RECAD Office Policy or the Agency Brokerage Office Policy. Current Alabama license law requires that every brokerage has an ADOP on file, and that every licensee in that brokerage is given a copy and an explanation of its meaning on a yearly basis from the qualifying broker. The law further requires that licensees sign a copy of the ADOP, acknowledging that they have received it and it has been explained to them. So let's move forward about the new ADOP requirements as of April 18th, 2025. Again, this guide is for information purposes only and not intended as legal or business advice. When the law changes on April 18th, 2025, the above requirements will remain in place. Before then, qualifying brokers will need to take the following steps. Step 1. Add general information about your company's compensation to your ADOP. See the next page for sample text. Step 2, distribute the updated ADOP to all licensees in your company. Explain it to them and ask each person to sign a copy acknowledging that they have received it. And finally, on step 3, ensure that all licensees in your company understand that consumers must receive a copy of the ADOP along with the RECAD Brokerage's Service Disclosure Form. So, what if I don't have an ADOP? Again, in general, for brokers, your ADOP should follow the outline below, but you are free to add more information if you'd like. So, there is a title. Consumers might receive more than one company's ADOP, so include your company name in the title. First, write a couple of sentences explaining that this document outlines the brokerage services available from your company, in contrast to the RECAD Brokerage Services Disclosure Form, which reviews all types of brokerage services that are legal in Alabama. For help getting started, again, we're going to refer to some sample language on the next slide. Second thing you want to consider, your ADOP must list the brokerage services that your company offers. If you would like, you may also include information about what a consumer can expect if they select a particular brokerage service. For help defining or describing the brokerage services that your company offers, please review the following information. 1. RECAD Consumer Information Booklet, which is found in the Alabama Real Estate Administrative Rule 790-X-3-.13. You can also refer to the RECAD Brokerages Services Disclosure Form, and you can refer to the Alabama Real Estate Administrative Rule 790-X-3-.14. And finally, as of April 18th, your ADOP must include general information about how your company gets paid. Example language can be found on the next page, or you may create your own. So let's talk about the Alabama Realtors Sample Language Agency Disclosure Office Policy. Again, this guide is for information purposes only and not intended as legal or business advice. So the question is out there, are you having trouble figuring out where to start with creating or updating your agency disclosure office policy? So HAAR has put together the following sample language to help. You may use the language below exactly as it is written or as a starting point to create your own language. However, please be aware that HAAR is unable to review or approve language that you create. That should probably be done through your own legal counsel. So let's talk about the ADOP and suggested language in this sample introduction paragraph. And that would read, thank you for considering working with quote-unquote example realty. We have given you a copy of the RECAD Brokerage Services Disclosure Form, which reviews all the brokerage services that are legal in Alabama. We are giving you this agency disclosure office policy to inform you of the brokerage services that Example Realty offers. If you have any questions, please ask us. Now here's sample compensation language for the ADOP. Again, note any of the sample text below that is written in italics will need to be edited to fit your brokerage's compensation model. So here's the notice. Quote unquote, Example Realty's compensation is not set by local, state, or federal law or by the rules of any realtor association, and it is negotiable. Please be advised that you may speak with multiple companies about their services and compensation before signing a contract with a company. So on the seller side, and language for the ADOP, at Example Realty, we charge, and here's where it's in italics, we charge a flat rate / percentage of the sales price / upfront fee to list and market your property. We will determine a specific amount rate of compensation in a listing agreement, which is a contract between you and Example Realty. If you choose to work with us, your payment will be due, again, you provide the specific timing, and this is where you would also include your own language. If you were to charge any type of cancellation or reimbursement fee, that you would include it in this section. So please remember this, that to please read your listing agreement carefully and ask us about any terms you don't understand or would like to negotiate before signing the document. You may be asked by a prospective buyer to help pay their real estate agent's compensation. This decision is up to you, and Example Realty will never require you to pay the buyer's agent in order to list your property with us. Let's talk about some suggested language for the ADOP for buyers. So again, we're using at Example Realty, we charge, and this is where you would enter in your specific or multiple different compensation formats, a flat rate / percentage of the sales price / upfront fee. to help you locate and purchase a property. We will determine a specific amount or rate of compensation in a buyer agreement, which is a contract between you and Example Realty. We will work with you to try to get the seller to pay as much of our compensation as possible. However, any remainder that the seller does not pay will be due from you, and then you would put that timing. Please read your buyer agreement carefully and ask us about any terms you don't understand or would like to negotiate before signing that document. Okay, we're going to move on to some more key provisions of HB 230, but I hope that was helpful for brokers, and again, how to either update their ADOP based on the new requirements of HB 230. So again, what are the key provisions pertaining to written agreements? So Act 2025-59 clarifies that consumers in Alabama cannot be required to sign a premature binding contract simply to view a property. So after a consumer has had time to build a relationship with a licensee, the law requires a written agreement between the licensee and consumer at specific times. So for buyers, before submitting an offer to purchase, you're going to need the RECAD, the ADOP, and then just before writing an offer is the written brokerage agreement. Remember, the only thing you need first in order to show the property for buyers is the RECAD and ADOP. But you will now be required to present a written brokerage agreement before submitting an offer. Again, that's the kind of the shift between the timing of when particular forms are being presented compared to the prior NAR settlement, and now this is the state law requirement for HB 230. So written agreements, okay, sellers, this will be done. This is what the forms that will be required before listing a property: the RECAD, the ADOT, and the listing agreement. Remember, the RECAD will talk about general compensation models. The written brokerage agreement must include your specific compensation amount or rate for the transaction. So the last key provision of HB 230 that we haven't discussed yet is referral agreements. So HB 230 requires referral agreements to be made in writing for both residential and commercial transactions. These new requirements will apply to all Alabama real estate license holders, not just realtors or realtor MLS participants, effective April 18th, 2025. Please continue current business practices until the law changes on April 18th. So let's go ahead and take a shift over to forms. Do a little deeper dive on that. These are the forms that you will need to use pertaining to HB 230. And let's go ahead and take a look into that. Now, I will point out, AAR has created state forms. Bally MLS will be using their forms and creating some new forms to accommodate HB 230. You are not mandated to use any particular form. So again, those are out there for you, and we'll go ahead and take a look at some of the local forms here initially. So let's talk about, again, before touring a home, there's going to be a couple new documents just based on HB 230. That's the RECAD, the Real Estate Brokerage Services Disclosure, and the ADOP. And as you'll notice in the asterisk here, the ADOP will be provided to you by your broker. You will not find this in Paragon under MLS documents, or online at AREC, or online under the resources for AAR. The ADOP, the Agency Disclosure Office Policy, will be created and provided to you by your broker. So the next set of forms, before listing a home, there's going to be 3 documents. So one is the RECAD, right? The Agency Disclosure Office Policy, and a written brokerage agreement, which would be the listing agreement. So before you may submit an offer to purchase on the buyer's behalf, a written buyer brokerage agreement, whether agency or transaction brokerage, that includes your specific compensation amount and or rate is going to be required. So the nice thing about this, we're going to look at the current Valley MLS form. It's the exclusive buyer agency agreement. So here's just the top half sample of that form that you should be very familiar with. So you had been using this before you could tour a home. This is now going to be required before submitting an offer, right? So this is a single agency representation. We are creating that document that will be ready and for the transaction brokerage agreement. Here's a sample of that. You will be able to find these last two forms in Paragon under MLS documents. So again, we have the single agent and now the transaction brokerage agreement document that you should be providing before writing an offer on a home. So if you remember, the other written agreements are required based on HB230 is referral agreements. Again, those must be in writing, and Valley MLS has a form for that, which is called the outgoing referral form. So again, all referral agreements be made in the form of a written contract, and the new law applies to both residential and commercial transactions. Here's what the Valley MLS outgoing referral form looks like. So that is in Paragon under MLS documents, and that is available to you, and no changes are being made to that. So a lot of information has been covered here in about the last 25 minutes or so. Let's go over some FAQs, because I know this is brand new, and we've got some heads tilted to the side thinking, I think I've got it, but maybe we could cover this one last time. And that's what we're going to do in the following slides. And then we're going to wrap up with some resources that'll be available to you. If you ever get stuck or anything, we'll wrap up with again, a full list of resources that you can obtain to help get you through this transition. So thank you to HAAR Legal Counsel, who has been very responsive and receptive to our questions and providing information and resources on a timely basis. So this comes from HAAR, and let's start up from the top. And so let's go over the review of the FAQs, so we cover everything from top to bottom moving forward. So what does the new law do? The new law is related to three main topics: RECAD, brokerage agreements, and referral agreements. So first, RECAD. This affirms that you must present the RECAD brokerage services disclosure to the consumer before any confidential information is exchanged or any brokerage services, including a property tour, are rendered. This newly requires that one, general information about how your brokerage is compensated to be added to your ADOP. This is a requirement under Alabama Code 34-27-82. And finally, a copy of your ADOP is presented to the consumer along with the RECAD. Let's talk about brokerage agreements. So this eliminates the requirement for prospective buyers to have a brokerage agreement in place before a property tour may take place. Instead, the updated license law will now have the following time requirements for buyers. A written brokerage agreement, whether agency or transaction brokerage, must be in place before an offer to purchase may be prepared or submitted on behalf of the buyer. This applies to licensees working only with the buyer. Listing agents who are also providing transaction brokerage services to the buyer, and limited consensual dual agents. For sellers, a written brokerage agreement must be in place before any property may be listed for sale by a licensee. Additionally, all written brokerage agreements must include the specific compensation amount or rate that the licensee will receive from the transaction. Compensation may not be listed in the form of a range or words such as to be determined, varies, or depending on seller's willingness to pay. And finally, under brokerage agreements, all other NAR rules regarding buyer agreements and listing agreements will remain in place. Let's talk about referral, the third piece of the new law, which is referral agreements. And again, this requires that all referral agreements be made in the form of a written contract. Okay, let's move along to the next question. Is RECAD required for buyers attending an open house? No. Licensees are not required to provide the RECAD brokerage's service disclosure form and the agency disclosure office policy to prospective buyers attending an open house. Next question. Is RECAD required for a listing agent who is showing their listing to a prospective buyer on private tour, not an open house? Yes. If a prospective buyer is not working with another licensee, the listing agent must provide the prospective buyer with the RECAD brokerage's service disclosure form and agency disclosure office policy before the tour may take place. Does the new law mean I can't enter into a brokerage agreement with the buyer before a tour or at some point before I help them submit an offer to purchase? No. It is still a best practice to enter in a written brokerage agreement with the buyer as early in the home buying process as the buyer is willing to do. If you have a buyer consultation meeting before a property tour and the buyer would like to sign a brokerage agreement, you may legally do so. Also, if during the home search process the buyer would like to sign a brokerage agreement before submitting an offer to purchase, that is also permissible. Where do I get a copy of my agency disclosure office policy? Contact your qualifying broker for a copy of your ADOP. If you already have a copy, be sure to verify it is the most updated version based on HB230. If I am a qualifying broker, what do I need to do to my brokerage's agency my ADOP to make it compliant with HB230? To be compliant with Alabama real estate law as of April 18th, 2025, your brokerage's agency disclosure office policy will need to include both the brokerage's services that your company offers and 2, general information about how your company is compensated. When working with sellers, what documents are required by HB230 and when? HB230 requires the following documents when working with a seller. At your initial meeting with the seller, you must provide the RECAD brokerage services disclosure and 2, the ADOP. And that is to be updated by your qualifying broker to include general information about your brokerage's compensation models. The next thing about when working with a seller, before you may list their property for sale, a written listing agreement, whether agency or transaction brokerage, that includes your specific compensation amount or rate. Okay, so when working with buyers, what documents are required by HB230 and when? HB230 requires the following documents when working with a buyer. So at your initial meeting with a buyer, 1, RECAD brokerage's services disclosure is required, and 2, your ADOP, which is updated by your qualifying broker to, again, include general information about your brokerage's compensation. And before you may submit an offer to purchase on the buyer's behalf, a written buyer brokerage agreement, whether agency or transaction brokerage, that includes your specific compensation amount or rate. Okay, we are moving along on slides here, so we'll be wrapping up here in just a few moments, just a few more slides to go. So next question is, should I be using a touring or showing agreement? Now, AAR does not recommend using a touring or showing agreement, but you are not legally prohibited from using one. you can reach out to the AAR legal line to get more clarification on that. NAR made rules related to buyer agreements last fall. How does HB 230 impact those rules? These changes are Alabama law and supersedes NAR's rule regarding the timing of buyer agreements. NAR's other rules, such as the requirement that you obtain the seller's approval for any offers of compensation and the prohibition against amending your buyer agreement to allow for additional compensation offered by the seller or seller's broker, remain in place. So, do I follow Alabama law or NAR rules? All Alabama licensees should follow Alabama license law. Alabama law supersedes NAR rules or any other private organizations. Where Alabama license law is silent, realtors organization members should follow NAR rules or guidelines. So here's the last FAQ before we wrap things up. And that question is, how does HB 230 impact commercial transactions? HB 230 will not impact the types of consumers the RECAD disclosure must be given to. Specifically, RECAD is not currently required when working with corporations, nonprofits, professional corporations, professional associations, LLCs, partnerships created under the Uniform Partnership Act, real estate investment trusts, business trusts, charitable trusts, family trusts, and governmental entities. This can be found under Alabama Code 34-27-82D. This will continue to be the case for HB 230. The new law related to brokerage agreements will apply to commercial transactions. So this means as of April 18th, in all commercial transactions, you must have a written brokerage agreement that includes your specific compensation amount and or rate in place no later than, now for sellers, before the property is listed, and for buyers, before an offer to purchase may be submitted on the buyer's behalf. Finally, the new law requiring referral agreements are to be made in writing applies equally to both residential and commercial transactions. So, we have one last slide to go here, and I want to leave you with some additional resources for you to make sure that you are up to speed and can use the information at sales meetings or share with agents in your office who'd like to get a little bit more detail about HB 230. So HAAR has created a URL at HAAR.realtor/HB230. That is where you're going to find this on-demand training video, as well as links to the following below here at AAR. So you'll have links to HB 230 resources at the state level, as well as here's the link and information you can find at alabamarealtors.com/legal-line. So that's available to you. You can also email legalhelpdesk@alabamarealtors.com. I hope this information has been helpful for you, and please share this information with other practitioners. Again, this is HB 230 that's required for not just realtors, but licensees across the state of Alabama, effective April 18th, 2025. Thank you for taking the time to watch this on-demand tutorial. Best wishes to you in applying HB 230 to your new business practices.